Court rise. Yes, Mr. Ike.
Having considered the case over lunch, can I make two short points, one returning to Article 28 of the ICC statute and one factual, and then take your lordships to the history of the international law concept of joint criminal enterprise and the international instruments first,
Yes.
and perhaps then return to the Canadian cases where they fit in their chronology, if I may. Your lordships may still have volume 4 open, which was the ICC statute we looked at before the short adjournment, and I think my Lord Brown asked me about Article 28, and the only point I wish to make is that, of course, the Secretary of State here hasn't relied on Article 28, and Article 28 is very specific in relation to the fact that the crimes have to be committed by forces under his or her effective command or control, and he either knew or, owing to the circumstances, should have known that the forces were committing, or he has failed to take all reasonable steps. So that, of course, on the evidence here, would not have been open to the Secretary of State, even if Article 28 might otherwise have provided an avenue for such a conclusion. The other short point on the statute I wish to make is to draw your lordship's attention to Article 10, which expressly says that nothing in this part, i.e. the definition of the various crimes, shall be interpreted as limiting or prejudicing in any way existing or developing rules of international law for purposes other than this statute. So it preserves existing definitions of war crimes, crimes against humanities and the like. But also to say that of course only relates to Part 2 and not to Part 3, which includes Article 25 on responsibility. Can I then just briefly make one point on
so when you said 28 doesn't, you couldn't, what was wrong with 28? So I'm just not...
Sorry, 28, if your lordship looks at Article 28,
yes.
In terms of the material which is available to the Secretary of State in this case, which your lordships have seen, it limits, it says in addition to the grounds of criminal responsibility which we've looked at,
Yeah.
there is an additional ground
Yeah.
which applies to military commanders who, in relation to acts of those under their effective command or control, which i.e. requires evidence to show that it was one of the 9 or one of the 45 who this individual had control order who committed the crime. But that, of course, is not the Secretary of State's case. The Secretary of State's case is that he was complicit in the larger war crimes committed by the intelligence unit of the LTTE, and not pointing at individual. So this again links back, which is what we said is the fault of the Court of Appeal, links back to the specific crime and requires the identification of a particular offence and the perpetrator of that offence in order to make Article 28 stick in relation to a commander, which is why it's not relied on by the Secretary of State in this case. It was really only to try and come back to the point raised by my Lord Brown about the overlap, and it isn't in that sense an overlap. It provides an additional basis for liability, which here on the evidence is not made out, and the Secretary of State isn't relying on. Can I then just briefly make the point on the facts? Your lordships took me to the transcript of the interview at of the respondent to the Secretary of State in the 4 volume. And having looked at that again, I just wanted to draw your lordship's attention to questions 94 through to 103 at page 142. just to put in context the Secretary of State's view of this individual's role within the intelligence division. And your Lordships will see at the bottom of 141, before you left the LTTE, what was the name of your immediate superior, Perrin-Pan? What was the role of Perrin-Pan's position? He was the Vavanica District Intelligence Chief. He was also in charge of particular activities going on in Colombo. Who is his superior? Potu Aman, who was LTTE's intelligence chief, and who was Potu Aman's superior was Prabharan, who is the leader of the LTTE. And then he says, I was second in charge of the combat division when he was second in command to the person who was the intelligence chief for that district and responsible for activities in Colombo. And then at 103, of course, he says that he is concerned for his, or he fears persecution on the basis that he was with the LTTE and left them, and I was in their intelligence branch. They might think I will pass on information. I could be in danger of them as well, which certainly to the Secretary of State suggested that his role was more than a mere uniformed foot soldier, taking part in what might otherwise be termed regular combat operations.
So what he fears at the end there is
his persecution by the LTTE arising out of a risk that, having been second in command of the regional intelligence division, he might be or second in command to the person who was responsible for the intelligence division's activities in Colombo, or some of them anyway. He might be able, or he might have passed on information which he shouldn't have.
yes.
Your Lordship, then taking the development of the international criminal law historically, what I would like to do is take your Lordships to the extracts we have from the judgment of the International Military Tribunal in relation to two particular provisions of the London Charter, and this is Articles 9 and 10. The judgment or the extracts your Lordships will find in volume 9 of the authorities at tab 70. And the London Charter, insofar as it's relevant to this case, your Lordships will have it, volume 3, 29. However, the starting point, what I wanted to draw your Lordship's attention is the approach of the tribunal to Articles 9 and 10, which are, of course, provisions of an international instrument drawn up for the purposes of crimes against humanity and war crimes, and as such, we would respectfully submit, clearly falls within the definition in 1FA. And at 9 we have, at the trial of any individual member of any group or organisation, the tribunal may declare, in connection with any act of which the individual may be convicted, that the group or organisation of which the individual was a member was a criminal organisation. After receipt of the indictment, the tribunal shall give such notice as it thinks fit. The prosecution intends to ask the tribunal to make such a declaration, and any member of the organisation will be entitled to apply to the tribunal for leave to be heard. The tribunal shall have the power to allow or reject the application. If the application is allowed, the tribunal might direct in what manner the applicant shall be represented and heard. Article 10 of the Charter makes clear that the declaration of criminality against an accused organisation is final and cannot be challenged in any subsequent criminal proceedings against a member of that organisation. Article 10 is as follows. In cases where a group or organisation is declared criminal by the tribunal, the competent national authority of a signatory state shall have the right to bring individuals to trial for membership therein before national, military or occupation courts. In any such case, the criminal nature of the group or organisation is considered proved and shall not be questioned. The effect of the declaration of criminality by the tribunal is well illustrated by Law Number 10, the Control Council of Germany, passed on the 20th December 1945, which provides each of the following acts is recognised as a crime. D. Membership in categories of criminal group or organisation declared criminal by the International Military Tribunal. We then have, over the page, the tribunal's consideration of this of this provision and says the last sentence of the acknowledges in the last sentence of the first paragraph, this is far-reaching and novel procedure. Its application, unless properly safeguarded, may produce great injustice. Article 9, it should be noted, uses the word the tribunal may declare, so the tribunal is vested with a discretion. This discretion is a judicial one and does not permit arbitrary action, but should be exercised in accordance with well-settled principles, one of the most important of which is that criminal guilt is personal and that mass punishment should be avoided. If satisfied that the criminal guilt of any organisation or group, this tribunal should not hesitate to declare it to be criminal because the theory of group criminality is new, or because it might be unjustly applied by some subsequent tribunals. On the other hand, the tribunal should make such declaration of criminality so far as possible in a manner to ensure that innocent persons will not be punished. Criminal organisation is analogous to a criminal conspiracy in that the essence of both is cooperation for criminal purposes. There must be a group bound together and organised for a common purpose. The group must be formed or used in connection with the commission of crimes denounced by the Charter. Since the declaration with respect to the organisations or groups will, as has been pointed out, fix the criminality of its members, that definition should exclude persons who had no knowledge of the criminal purpose or acts of the organisation, and those who were drafted by the state for membership, unless they were personally implicated in the commission of acts declared criminal by Article 6 of the Charter as members of the organisation. Membership alone is not enough to come within the scope of these declarations. So again, we see the beginnings of the concepts we talked about before the short adjournment, the need for knowledge, and the fact that that mere membership is not enough. At page 257, just above the leadership core of the Nazi Party headline, it notes that the indictment asked the tribunal to declare to be criminal the following organisations: the leadership core of the Nazi Party, Gestapo, the SD, the SS, the SA, etc. And then, in relation to the leadership core of the Nazi Party, it is made clear at page 258, first full paragraph. On 28 February 1946, the prosecution excluded from the declaration asked for all members of staff of the Ortsgruppenleiters and all assistants of the Zellenleiters and Blockleiters. The declaration also sought against the leadership corps, thus included Führers, Reichsleiter and Gauleiter and their staff and staff officer, Kreisleiter, etc., a group estimated to contain at least 600,000 people. Under its conclusion, then at 261, the tribunal records that the leadership corps was used for purposes which were criminal under the Charter and involved the Germanization of incorporated territory, the persecution of Jews, the administration of the slave labour programme, and the mistreatment of prisoners of war. Defendants Bormann and Saukel, who were members of this organisation, were among those who used it for these purposes. The Gauleiter, Kreisleiter and Ortsgruppenleiter participated to one degree or another in these criminal programmes. Reichsleitung, as a staff organisation of the party, is also responsible for these criminal programmes, as well as the heads of the various staff organisations of the Gauleiters and Kreisleiters. The decision of the tribunal on these staff organisations includes only the Amtsleiters who were heads of offices on the staffs of the Reichsleitung, Gauleitung and Kreisleitung. With respect to other staff officers, the leadership corps, other than the Amtsleiters referred to above, the tribunal will follow the suggestion of the prosecution in excluding them from the declaration. The tribunal declares to be criminal within the meaning of the Charter the group composed of those members of the leadership corps holding the positions enumerated in the preceding paragraph who became or remained members of the organisation with knowledge that it, the organisation, was being used for the commission of acts declared criminal by Article 6 of the Charter, or who were personally implicated as members of the organisation in the commission of such crimes. Basis of this finding is the participation of the organisation in war crimes and crimes against humanity connected with the war. The group declared criminal cannot include, therefore, persons who had ceased to hold the positions enumerated in the preceding paragraph prior to 1st September 1939. In relation, the next organisation considered is the Gestapo and the SD, and the tribunal's conclusion in relation to that is set out at 267. And again, the first two sentences set out the criminal purposes for which the Gestapo and the SD were being used. And then the tribunal says this: in dealing with the Gestapo, the tribunal includes all executive and administrative officials of Amt 4 of the RSHA, or concerned with Gestapo administration and other departments of the RSHA, and all local Gestapo officials serving both inside and outside of Germany.
Where are they saying
Sorry,
this?
267, my lord. Under the heading conclusion.
Yes,
About 6 lines down, my lord.
I see.
I apologise. But not including the members of the Border and Customs Protection or the Secret Field Police, except such members as have been specified above. And at the suggestion of the prosecution, the tribunal does not include persons employed by the Gestapo for purely clerical, stenographic, janitorial or other unofficial routine tasks. Dealing with the SD, the tribunal includes EMTA 3, 4, as 3, 6 and 7 of the RSHA and all other members of the SD, including all local representatives and agents, honorary or otherwise, whether they were technically members of the SS or not, but not including honorary informers who were not members of the SS and members of the Abwehr who were transferred to the SD. The tribunal declares to be criminal within the meaning of the Charter the group composed of those members of the Gestapo and the SD, holding the positions enumerated in the preceding paragraph, who became or remained members of the organisation with knowledge that it was being used for the commission of acts declared criminal by Article 6, or who were personally implicated as members of the organisation in the commission of such crimes. That really just to illustrate the position taken by the drafters of the London Charter and by the tribunal in relation to the liability of persons who are members of these organisations with knowledge that they were being used for the commission of war crimes or crimes against humanity.
But is it significant, going back to 256, very near the beginning of what you read, they're talking about convicted of the crime of membership. Membership is actually the crime. I mean, is that similar to what we have here?
My Lord, I have to give 2 aspects to the answer. One is, as we will see when I take the court to the next authority I want to go to, this is used as a starting block for the development of the breadth of the concept of certainly the third category of joint criminal enterprise as we understand it, and it is relevant in that sense. But there is, of course, and the Secretary of State did not rely on mere membership, and I made clear the position. But of course, it is further relevant that the approach of the tribunal illustrated here is in relation to an offence encompassed by an instrument which, in our respectful submission, is covered by, or is relevant to the interpretation of 1FA, because it is an international instrument drawn up for the purposes of such crimes.
The way it seems to work is that you've got the definition of the crime at 255, and then they, by interpretation, they say that mere membership's not good enough, and by process of subtraction, you can see in each of the passages you refer to various people who are excluded because they're menials or whatever else it is, and the touchstone seems to be knowledge.
My Lord, yes.
Coupled with membership.
Which is why, as we will see, this is really the starting point of that jurisprudence. The tribunal there, very conscious of the breadth of the power it had conferred on it by Articles 9 and 10, and by the Control Council Law number 10, which of course meant that people could be put to death for mere membership of an organisation, potentially, introduced the kind of criteria, as my Lord Hope put to me, by way of subtraction, which are now relevant by reading the concept of joint criminal enterprise and by reading that, and certainly the third category of joint criminal enterprise, into the word commit under the ICTY statute. But it is, as we will see, this is the start of the development of that process. If I can then perhaps ask your Lordships to take up the authority which the amicus curiae submission to the Extraordinary Chamber in the Courts of Cambodia, drafted by the editorial board of the Journal of International Criminal Justice, as perhaps a convenient summary of the law as it certainly stood when that was drafted on the 27th of October 2008 in relation to joint criminal enterprise, trying to cut down on the different individual cases I need to take your lordships to. It's volume 5, my lords, tab 43. And your lordships will see there the authors of the amicus curiae brief. Professor Cassese, as your lordships will be aware, was also one of the judges on the ICTY appeal chamber in Tadic. Mary Deming Fan, Vanessa Talman, and Salvatore Zappada. Paragraph 1 makes clear that this was drafted at the invitation of the pre-trial chamber. And then perhaps at page 7 of 40, summary of the analysis, JCE is not a crime, but a form of criminal liability.
So
The
what
doctrine,
JC is what? Joint?
sorry, this is 7 of 40, paragraph 20, my lord. Under the
Joint
heading
criminal
summary of
enterprise.
analysis.
It's JC's joint criminal enterprise.
Yeah, sorry, JCE stands for joint criminal enterprise. It's not a crime but a form of criminal liability. The doctrine is a crucial part of international criminal law, ensuring that individual culpability is not obscured in the fog of collective criminality and accountability evaded. The principles of JCE as a mode of criminal liability crystallized after World War II and were customary rules of international criminal law by 1975. Analysis and systemization of post-World War II cases implementing the principles of the charters of the International Military Tribunal and Control Council Law Number 10 showed 3 categories of JCE as a mode of liability. 1, a basic form where all participants acted pursuant to common design and possessed intent to commit the crime, even if each participant carried out a different role and offered varying levels of contribution. 2, a systemic form, essentially a variant of the first category, applicable to detention and concentration camp cases. And 3, an extended form ensuring accountability where another perpetrator commits a crime that, though outside the common design, was a natural and foreseeable consequence of effecting the common purpose. Those 3 forms of JCE liability are then further analysed starting at paragraph 23, starting at page 9 of 40.
And which is ours, if any?
My lord, we're in a sense here in number 3, or to some extent, as we will see, looking at the case, we're all potentially 1. We're not in 2 because this is not a detention camp scenario. But as I will seek to show you, lordships, by reference to the case law referenced by Professor Cassese and his colleagues, it is potentially capable to fall under both 1 or 3, but certainly 3, my lord. But perhaps I can, if I take your lordship to that, then we. The 3 forms are the first and most widespread category is liability for acts agreed upon either when making the common plan or design or when such plan materialised extemporaneously, where all participants shared the intent to commit the concerted crime, regardless of whether the accused was the one who actually physically perpetrated the crime. All are responsible, whatever their role and position, in carrying out the common criminal plan. Moreover, the ICTY Appeals Chamber has recently clarified that in all 3 categories of JCE, the person who carried out the actus reus of the crime need not have been a member of the JCE, so long as the crime committed was part of the common purpose. And that's a reference to Brudnin. The second mode of liability, which is essentially a variant of the first, applies to persons carrying out a task within a criminal design implemented in an institutional framework, such as an internment or concentration camp. The systemic form of JCE does not require proof of a plan or agreement, whether or not extemporaneously. Plainly, an internment camp where inmates are severely ill-treated and even tortured, not only the head of the camp, but also senior aides and those who physically inflict torture and other inhuman treatment are responsible. Those who discharge administrative duties indispensable for the achievement of the camp's main goals, for example, to register the incoming inmates, record their death, give them medical treatment, provide them with food, or prevent the detainees from leaving may also incur criminal liability. And we would just highlight the breadth of those who are potentially covered. They bear this responsibility so long as they have knowledge of the serious abuses being perpetrated and willingly take part in the functioning of the institution. Criminal responsibility is only logical and natural. By fulfilling their administrative or other operational tasks, they contribute to the commission of crimes. Without their willing support, crimes could not be perpetrated. Thus, however marginal their role, they constitute an indispensable cog in the murdering machinery. For this mode of liability, courts can legitimately hold that each participant in the criminal institutional framework was not only cognizant of the crime which the institution or its members engaged, but also implicitly or expressly shared the criminal intent to commit such crimes. It cannot be otherwise, because any person discharging a task of some consequence in the institution could refrain from participating in its criminal activity by leaving it. Exceptions are made for those who, for example, merely sweep the hallways or clean the laundry, for they do not make a significant contribution to implementing the common criminal purpose. And again, we see reflected in this the passages I took your lordships to in relation from the IMT as to the approach to liability. And it's clear that the reach is broad and really only excludes those who, as it says here, sweep the hallways or clean the laundry, as their contribution is not significant. The third mode of responsibility concerns those participants who agree to the main goal of the common criminal design, for instance, the forcible expulsion of civilians from an occupied territory, but do not share the intent that one or more members of the group entertained to also commit crimes incidental to the main concerted crime, for instance, killing or wounding some of the civilians in the process of their expulsion. This mode of liability only arises if the participant, who did not have the intent to commit the incidental offence, was nevertheless in a position to foresee its commission and willingly took the risk. A clear example in domestic criminal law of this mode of liability is that of the bank robbery, where 3 or more people agree to rob the bank carrying guns. They have no intent to kill anyone and do not agree to kill, may even agree not to kill, and that the guns are only to threaten. During the robbery, one of them fires his weapon and kills the teller. In this scenario, all members of the JCE are liable for the killing, because it was foreseeable that by carrying guns someone could be killed. Then over the page, at page 11, still on that example, 6 lines in, although he did not share the mens rea of the murder, he foresaw the event and willingly took the risk that it might come about. Plainly, he could have told the other robbers that there was a serious danger of a murder being committed. Consequently, he could either have taken the weapons away from the armed robber or withdrawn from the specific robbing expedition, or even dropped out of the gang. Arguably, for criminal liability under the third category of JCE to arise, it is necessary for the crime outside the common plan to be abstractly in line with the agreed upon criminal offence. In addition, it is also essential that the secondary offender had a chance of predicting the commission of the unconcerted crime by the primary offender. And again, that takes us to the concept of knowledge, which we discussed before the short adjournment, but perhaps also in part answers the question I think posed by my Lord Brown about the question of control and whether somebody whether it is a necessary component that he has control. It is clear from this that in order to fall within the third category, the only control he needs is over himself, namely to withdraw or take actions against those on the same level of the hierarchy in order to avoid the crime being committed. Over the page at paragraph 27, we then see, thus in addition to shared intent, dolus eventualis, a civil law concept similar to the common law conception of an advertent recklessness, can suffice to hold criminally liable for the extra offence those participants in the common plan who willingly took the risk. And at the end of that paragraph, the world community must defend itself from this collective criminality by holding those responsible for the full extent and reach of their crimes. The differing degrees of guilt may be taken into account at the stage of sentencing, referring there to the decision of the British military court in the Otto Sandrock trial. JCE liability is distinct from other modes of liability, like aiding and abetting. The JCE doctrine serves an important purpose in capturing culpability in the context of collective criminality. there are two main differences between aiding and abetting and JCE liability. In actus reus, contribution with substantial effect on the perpetration of the crime are required for aiding and abetting liability. Whereas for JCE liability, it suffices if acts are simply directed to the furtherance of a common plan. Reference to the case of Kwoczka in the ICTY in footnote 48. The ICTY now describes the correct level as significant. See Brannin, Appeal Chamber, paragraph 47. It is worth noting that the accused does not have to personally perform any part of the actus reus. Mental state. The requisite mens rea for aiding and abetting liability is knowledge that the acts performed assist in the commission of the crime, whereas more is required for JCE liability. Either intent to pursue the common purpose, or such intent plus foresight that crimes outside the common purpose are likely to be committed. So, and then going on, so that's the distinction with aiding and abetting. We then go to paragraph 30. So, paragraph 29, my learned friend Mr. Dillon rightly points out, deals with the overlap with complicity. Since the JCE doctrine is based on the notion of intent, or intent plus foreseeability, and is always premised on a link of causation, it overlaps to a large extent with national law doctrines of liability for collective crimes, even where national systems rely on concepts such as co-perpetration, coaction in French, or complicity, complicité. Professor Cassese then goes on, importantly, we say, to show how this notion came to be accepted, and says the notion of, in paragraph 30, the notion of JCE is more crucial in international criminal law than at the domestic level. In the world community, international crimes such as war crimes, crimes against humanity, and genocide share a common feature. They tend to be expressions of collective criminality in that they are perpetrated by groups of individuals, military details, paramilitary units, or government officials acting in unison or in pursuance of a policy. When such crimes are committed, it's extremely difficult to pinpoint the specific contribution made by each individual participant in the collective criminal enterprise, because one, not all participants acted in the same manner, but rather each of them may have played a different role in planning, organising, instigating, coordinating, executing, or otherwise contributing to the criminal conduct. And two, the evidence relating to each individual's conduct may prove difficult, if not impossible, to find. These considerations a fortiori apply to crimes such as murder or aggravated assault committed by a whole crowd. Paragraph 32. To obscure responsibility in the fog of collective criminality and that the crimes go unpunished would be immoral and contrary to the general purpose of criminal law, protecting the community from deviant behaviour that causes serious damage to the general interest. This damage is often all the more severe in the context of collective criminality. JCE doctrine, as the systemization of principles of customary international law in existence since the post-World War II period, is a vehicle of accountability against such harm. And we then see at paragraph 33, the court moving on to the historic background. JCE doctrine is based on the rules and principles of national law and international judicial decisions. Customary nature of these international rules formed before the 1975-75 period of crimes considered by the ECCC. Through the case law of the Charter of the International Military Tribunal, 2, Control Council number 10 of 1945. JCE liability is not, therefore, a creation of the International Criminal Tribunal. Rather, Tadic elucidated customary international law and liability for collective criminality by synthesizing previously applied rules and principles into a general coherent framework. 34, second sentence. JCE doctrine holds individuals responsible for collectively undertaking offences, even if other members of the group or persons used by them physically perpetrated the crimes, because any legal system should deter and redress participation in common criminal purpose. One way to do so is to make an individual participant bear all the consequences of the intentional commission of concerted crimes, as well as the foreseeable consequences of joining a common criminal enterprise. We then, over the page at paragraph 36, see reference to Article 6 of the Nuremberg Charter. In the 4 lines down, Article 6 of the Nuremberg Charter established, pursuant to the agreement conferred on the International Military Tribunal, the power to try and punish persons who, acting in the interests of the European Axis countries, whether as individuals or as members of organisations, committed crimes against peace, war crimes, and crimes against humanity, and provided that leaders, organisers, instigators, and accomplices participating in the formulation or execution of a common plan or conspiracy to commit any of the foregoing crimes are responsible for all acts performed by any person in execution of such plan. And again, we say that is important. At paragraph 40, the court then, Professor Casese then looks at the Nuremberg Charter and Control Council Law number 10, which established the following mode of criminality, and it then quotes, any person without regard to nationality or the capacity in which he acted is deemed to have committed a crime as defined in paragraph 1 if he was A, a principal, or B, was an accessory to the commission of any crime, or ordered or abetted the same, or C, took a consenting part therein, or D, was connected with plans or enterprises involving its commission, or E, was a member of any organisation or group connected with the commission of any such crime, or F, with reference to paragraph 1A, if he held a high political, civil or military position. So again, we would highlight, as Professor Casese has, C and D in that. And this provision clearly envisages criminal liability for participation in a criminal enterprise through either consenting participation in such an enterprise or connection with criminal plans of a group or a criminal enterprise of a multitude of persons. Both the principal perpetrator and any person connected with plans or enterprises involving the commission of a crime were deemed to have committed the crime. The Professor Casese then goes on to look at paragraph 42 on the judgment of the International Military Tribunal, where the tribunal held that Article 6, reference to criminal responsibility for acts performed in execution of a common plan or conspiracy, did not add a new or separate crime to those already listed. Rather, the text was designed to establish the responsibility of persons participating in a common plan. And then there's the quote, argument that such common planning cannot exist, whether its complete dictatorship is unsound, plan in the execution of which a number of persons participate is still a plan, even though conceived by only one of them, and those who execute the plan do not avoid responsibility by showing that they acted under the direction of the man who conceived it. Hitler could not make aggressive war by himself. He had to have the cooperation of statesmen, military leaders, diplomats and businessmen. When they, with knowledge of his aims, gave him their cooperation, they made themselves parties to the plan he had initiated. There's then consideration of the individual forms of JCE, the individual categories, and we have the consideration of category 1 starting in paragraph 43. But the passage I want to draw your Lordship's attention to is paragraph 45. In Feuerstein and others, the Judge Advocate of a British military court explained that to be concerned in the commission of a killing meant more than just being the direct cause of death by inflicting the fatal injury. It also means an indirect degree of participation. Judge Advocate elaborated, a person can be concerned in the commission of a criminal offence who, without being present at the place where the offence was committed, took such a part in the preparation for this offence as to further its object. In other words, he must be the cog in the wheel of events leading up to the result which in fact occurred. He can further that object not only by giving orders for a criminal offence to be committed, but he can further that object by a variety of other means. And the footnote there refers to the case of Dr. P, where a doctor was convicted for aiding and abetting murder and for crimes of humanity because his acts contributed to the overall planning of the killing of mentally disabled people, where he officially examined the victim and foresaw the possibility that they might get killed, holding that the degree of involvement is totally irrelevant to the conviction under Article 2.1.2 of the Control Council law. Then, at the top of page 21, the Judge Advocate also rejected the contention that accused could evade liability by claiming the offence could have occurred even without their participation, explaining that the accused could still be guilty without being vital links in the chain of causation, so long as the accused were concerned in the commission of the criminal offence and had guilty knowledge of the intended purpose of the crime. He then refers to the Einsatzgruppen case, where the prosecution argued to a US tribunal that lower-level accused Radetzky and Schubert, among others, were guilty of war crimes and crimes against humanity because they were members of Einsatz units with an express mission well known to members to carry out large-scale programme of murder, and members who assisted in the function of the units were guilty of crimes committed by the unit. Prosecution argued that Article 2.2 of the Control Council law was in line with recognised principles common to all civilised legal systems, and signified that those who take a consenting part in the commission of the crime, or who are connected with plans or enterprises involved in the commission of crime, or who belong to an organisation or group engaged in the commission of crime, were guilty together with the principals. The opinion and judgment of the tribunal found Radetzky and Schubert guilty of war crimes and crimes against humanity, because Radetzky took a consenting part in the crimes, and because of Schubert's general participation in the venture of the Einsatzgruppe D. So again, very much emphasising the broad reach even of Category 1, and perhaps in answer to the question my Lord Brown posed to me, which one do we say this individual falls within, we would say, on that basis, he is capable of falling within both. We then have the...
Well, Category 2, you're not pursuing, are you?
Category 2 is not a category on which we're relying, because it has historically been focused on detention camps and concentration camps, and of course that's not what this cause is concerned about. But what we are relying on is Category 1 and Category 3. The other passage I wanted to draw your Lordship's attention to, though, I think finally, is paragraph 67 of this amicus curiae brief.
67 or
67, my Lord, on page 30.
Yeah, okay.
May be worth clarifying that the notion of JCE in criminal law serves the specific purpose of capturing the reality of complex collective crimes without adopting one national model or the other. It is not necessarily the case that in all criminal law systems persons are punished by resorting to the notion of JCE or similar notions. What matters, and what the JCE doctrine tries to accomplish, is to do what in many national systems is done in different ways, to make each single individual participant in a common criminal plan accountable for all the offences which he contributed to carry out. This entails that an individual should be responsible for all those crimes which, although not explicitly spelled out in any agreement or common purpose among the participants, are the clear product of the implementation of the common criminal purpose. This phenomenon may well be labelled in different ways in different systems, however the underlying rationale seems to a large extent similar. Moreover, even if JCE or something similar does not exist in all domestic law systems, it may be justified by the general character of the national criminal system. Obviously, they do not deal exclusively with the extreme serious collective crimes. They deal with all kinds of criminal offences, and in most cases criminal law has to be applied to the less serious offences. However, granted that there may be reasons at the national level for limiting responsibility to the agreed-on crimes, such reasons do not seem to be equally appropriate in international criminal law. When one turns to this field of law, one has to take account of a fact, the risk that a multitude of persons decide to engage in some atrocities and not others, cannot allow them simply to turn a blind eye to all the perverse effects their common criminal purpose may entail. The JCE doctrine serves to make those who determine the avalanches accountable for the entirety of their acts to the fullest extent. In addition, this legal regulation should have the preventive effect against engaging in criminal conduct. The very creation of a situation of risk that leads to the perpetration of further offences calls for punishment. There is no reason to consider that the participants who deliberately agreed to engage in criminal conduct of very serious nature should not be required to pay attention to the potential perpetration of further atrocities by some members of the group. And we say that in this understanding of joint criminal enterprise, there are all the components which we identified, and which the Canadian cases and Guru identified, leading to the approach taken by those courts to 1FA and the concept of complicity. It's the cog in the wheel, the knowing cog in the wheel concept. Now, perhaps I can just briefly, and because I made reference to it earlier, very briefly, refer your lordships to the decision in Tadic.
Which he was aware of when you wrote this paper.
he was aware of because he part wrote the judgment.
Right.
So if I take your lordship, I will show your lordship how this falls together. Tadich is at volume 9, tab 67. Sorry, 69. And your lordship will see there, this is the appeals chamber of the ICTY, and Judge Antonio Casese is the second judge in a judgment handed down some 9 years before he wrote the amicus curiae brief. And your lordship will see, or will have seen from the amicus curiae brief, that it is heavily cross-referenced to, in the footnotes, to the ICTY jurisprudence up to October 2008. But the passage I really, if your lordship look at the index of the case, 5 at page Roman 2 deals with the concept of JCE, but really most of what's in here has been summarised. So what I just wanted to draw your lordship's attention to was a longer citation of the approach taken by the US tribunal in the Einsatzgruppen case we looked at in the amicus brief, and this is at page 86. And there we have a final case worth mentioning with regard to this first category, is the Einsatzgruppen case. With regard to common design, a US tribunal sitting at Nuremberg noted that the elementary principle must be borne in mind that neither the Control Council Law No. 10 nor under any known system of criminal law is guilt for murder confined to the man who pulls the trigger or buries the corpse. In line with recognised principles common to all civilised legal systems, the Control Council Law specifies a number of types of connection with crime which are sufficient to establish guilt. Thus, not only are principals guilty, but also accessories, those who take a consenting part in the commission of crime or are connected with plans or enterprises involved in its commission, those who order or abet crime, and those who belong to an organisation or group engaged in the commission of crime. These provisions embody no harsh or novel principles of criminal responsibility. If one then jumps down to footnote 245, the tribunal went on to say, even though these men, Radetzky, Ruhl, Schubert and Graf, were not in command, they cannot escape the fact that they were members of Einsatz units whose express mission, well known to all members, was to carry out a large-scale programme of murder. Any member who assists in enabling these units to function, knowing what was afoot, is guilty of the crimes committed by the unit. The cook in the galley of the pirate ship does not escape the yardarm merely because he himself does not brandish a cutlass. The man who stands at the door of a bank and scans the environs may appear to be the most peaceable of citizens, but if his purpose is to warn his robber confederates inside the bank of the approach of the police, his guilt is clear enough. And if we assume for the purposes of argument that the defendants such as Schubert and Graf have succeeded in establishing that their role was an auxiliary one, they are still in no better position than the cook or the robber's watchman. And of course, your lordships will recall that from the amicus brief, Schubert and Radetzky were both found guilty.
They had driven them there or something, is that right? But
My
hadn't
lord,
taken part in the actual shooting of the soldiers, is that right?
That's what I understand, my lord. The exact factual content of the Einsatzgruppen case is more difficult to pin down. But I mean, as we see from that last quote, it was, I mean, the focus in the end of the tribunal was to the fact that they were members of the Einsatzgruppen who had a job to do, and that job was that program was well known, and therefore any member who assists in enabling these units to function, knowing what was afoot, is guilty of the crimes committed by the unit.
Unless it's doing their laundry or sweeping their floor.
My lord will recall that looking at the judgment of the IMT and the passages I took you lordship to in the Casese amicus brief, is that the international tribunals have excluded those who did merely clerical jobs.
It's significant.
It is significant rather than substantial. So it is, they need to have made a significant contribution, but it is plain from this in our respectful submission and from the distinction drawn between all members of the Gestapo except those who cleaned the floors and swept the halls, that significant is not a particularly
But I
high
mean,
threshold.
have we got the same coincidence between the Gestapo and our people? I mean, here in the same footnote we just looked at, the Einsatz units whose express mission was to carry out a large-scale program of murder. I mean, you can't say that of the LTTE as a whole. I'm not sure on the facts whether you can say that of the intelligence unit as a whole either. The intelligence division, it's been called.
My lord, that again takes us back to what seems to be clear from the amicus brief and the case law on JCE, that the person who perpetrates it doesn't need to... what is necessary is that he knows the crime. This isn't on all fours. I accept that there wasn't... the evidence here... Sorry, two things. One is, of course, we're here concerned with criminal cases, and therefore the question the Secretary of State had to ask herself at the time was, are there serious reasons for considering that he was engaged in these crimes? And in our respectful submission, looking at the facts and what we know about the intelligence division of the LTTE, it is certainly reasonable to come to the conclusion that they are. But even if they are not, of course, the essence is that we have here somebody who there are serious reasons for considering that he knew of the atrocities committed by the intelligence unit and by the LTTE as a whole. And that was well known at the time. And he was a member, actually a member of some command responsibility, who assisted in enabling that unit to function. And he did so. He did so by commanding various units. He did so by acting as one of the chief bodyguards to the head of the intelligence division. He did so by various means throughout his time, even his time as an adult member of the intelligence division.
So everybody in the intelligence division falls foul of this, except the floor sweepers. I doubt very much they have any in that particular division. I don't know.
My lord, there are those, and then there are the questions of voluntary membership or whether they were...
Every voluntary member of the intelligence division, you say, falls within this.
Well, it's our submission that it would be not unreasonable to any willing, knowing, active member of the intelligence division of the LTTE would be capable of exclusion, would reasonably be capable of exclusion under 1FA on the basis that there are serious reasons for considering that he is and would be held by international courts, held responsible for the crimes committed by the intelligence division of the LTTE.
What about the third category, which is dealt with at page 89? It's a familiar trilogy, isn't it? The middle one is concentration camps, I think, and this is the third one that we saw before.
My lord, yes.
And he's dealing with that, which is a common design to pursue one course of conduct, where one of the perpetrators commits an act which is outside the common design, but nevertheless was of natural and foreseeable consequence.
Yes.
So it's not the same scenario as in the footnote, but nevertheless it's one which, as I understand the writer, still carries with it responsibility.
My lord, yes, it does. And of course the writer, as we know from the amicus brief, acknowledges that the difference in culpability can be taken account of at the sentencing stage in the criminal process, but the liability still arises. And of course the Einsatzgruppen case was a category 1 case, and my answer to your lordship earlier was that it's the Secretary of State's case that he's capable of falling into both, but even if he's not capable of falling into the exact Einsatzgruppen scenario, in our respectful submission, he is capable of falling into category 3. Again, looking at the facts I took your lordship to just after the short adjournment, he was second in command and the person at the intelligence division who was responsible for intelligence operations in Colombo, or some of them. And we know from the evidence of what the LTT was up to in Colombo, and it wasn't fighting a war between uniformed units. It was using suicide bombers, it was targeted assassination of officials. It was that kind of operation, all of which are a foreseeable consequence of what the unit was about.
I mean, the third category is where somebody goes too far, is it? Goes further than was contemplated. Is that what it's doing?
Well, my lord, there is, of course, but it is the question, the case law, the question under joint criminal enterprise is, as we understand it, and in our submission rightly is in how far was that a foreseeable consequence? Yes, of course, there may be a going too far which was not foreseeable, but this is expressly designed to deal with those cases where people do go too far, but it is a foreseeable going too far.
But does this sort of arise because, I mean, as a sort of a potential rebuttal to an objection? Well, I mean, because, I mean, as far as I know, there's nothing in particular to suggest that anyone did go further than was contemplated. But it might arise if the other side said, well, of course, we don't know whether he, I mean, for all we know, all these things may have gone further than any conspiracy in which or any enterprise to which he was party. I mean, other than that, I can't see what Category 3 has to do with it.
No, I agree.
My Lord, that may well be right, but again, we're here looking at whether the Secretary of State, considering whether there's serious reasons for considering that he was so responsible.
But he doesn't know anything of she doesn't have any particular reason to believe that there were people going further than was contemplated.
Well, no, but if they didn't go further, in relation to what the LTT routinely did with its operatives in Colombo, insofar as that wasn't going further than the common plan, then of course we don't even need to go to joint criminal enterprise.
That's exactly what I'm saying.
But insofar as the argument is, well, he is merely a foot soldier in a combat unit wearing uniform, our submission is he is a member of the intelligence unit. He's second in command to the person in charge of intelligence work of the LTT in Colombo. And he's therefore liable for the offences of the unit.
Category 1.
Yes, and that's why my answer to my Lord Brown was yes. He would satisfy that, but if he doesn't satisfy that, we would say he would fall within 3, but he would fall into 1 primarily.
Are you leaving, Professor Cassese?
I was, my Lord.
Because if you are, I wonder if you can help me on a passage that's quoted in the respondent's case, paragraph 34.
34
of the respondent's. Sorry, yes, it's the respondent's case, where there's a quotation from his book on international criminal law. Now, this falls between the two. If you take the date of it in the footnote, this is between 2 writings that we've been looking at. The Tadic case, of course, is later. One of the other writings, I think, was the amicus brief was in October 2008, wasn't it?
That was 2008, my Lord, yes.
And the thing we've been looking at is post-Tadic as well. But in 2003, he was writing what we see here, and the essence of it, I think, is what is referred to as objective criminal liability, which halfway down the page requires that a person is culpable for any breach of criminal rules. Do we get any help from this, or if Mr. Singh says he does, is he wrong about that?
Well, my Lord, in my respect, this isn't... the immediate answer is I'm not sure we get much help from that. In the 2008 amicus brief, he set out quite clearly what the extent of the liability is. This deals with as it says there, 2 notions. One is that he may not be held accountable for criminal offences perpetrated by others, but then by reference to national, ethnic, racial or religious group to which a person may belong is not accountable for acts performed by a member of the group in its individual capacity. So that, yes, of course, is a very different scenario from the scenario we're looking at, which is a tightly organised organisation which prides itself of its military discipline, which pursues a collective plan. And that paragraph, in my respectful submission, it deals with, in a sense, a different beast of organisation or group, because it refers to for example, a member of another Tamil group. You can't hold another Tamil responsible for the actions of the LTT or the leader of the LTT because he's extraneous to that process. And that would be by reference to his national, ethnic, racial or religious group. in my respectful submission, it doesn't take us any further in relation to the concept we've been considering, namely the question of a tightly organisation run along military lines in this
Yes, I
case.
see.
Does that answer
Yes,
your
thank you very
question?
much. Yep.
Now, very conscious of the time, my lords, I have my learned friend helpfully indicated that he wouldn't be in any difficulties if I took the rest of the day. So, with your lordship's permission, I would like to.
Well, we have it in mind to sit earlier tomorrow if necessary. We'll discuss that, I think, at the end of the day, Mr. Singh, if we may, to see how you think, how much time you think you need. So,
my lord, I'm grateful, but I will try and go to that. Can I then, following the chronological approach I've taken, could I then ask your lordships to, having identified what we say the international criminal law provides, briefly take your lordships to Krasnich, just to round this off, because of course that is the decision that led the Court of Appeal to invite submissions and led it to its conclusions.
yes.
And this is at takes up all of volume 6. And really, just to make the submission, there's, in our respectful submission, nothing in Krasnich which calls into question the analysis which we've just taken your lordship to, and perhaps just highlighting this by reference to paragraph 694 to 697 at page 239. And your lordship may be aware that the Krasnich case, as the introductory paragraph shows, is concerned with a Bosnia-Herzegovina politician who was the president of the assembly and a member of the Serbian Democratic Party's board, who was convicted of crimes against humanity and in various forms. Paragraph 4 at page 2, trial chamber in reaching its verdict found that he participated in a joint criminal enterprise whose objective was to ethnically recompose the territories under the control of the Bosnian Serb Republic by drastically reducing the proportion of Bosnian Muslims and Bosnian Croats.
Where is it?
Sorry, this is paragraph 4 at page 2. I apologise, my lord, I jumped back to just to set out the facts of that case. Consider that there was a leadership component of the group based in the Bosnian Serb capital of Pale, which included Krasnich, Karadzic, and other Bosnian Serb leaders. The rank and file of this joint criminal enterprise was based in the regions and municipalities of the Bosnian Serb Republic and maintained close links with the Pale-based leadership. There was then an appeal against that conclusion, inter alia on the basis that all he did was make speeches, effectively, namely political speeches, and that's what takes us to page 239, paragraph 694. So, the argument is at 690 to 238. During the appeal hearing, JCE counsel further developed the argument, stating that Krasnich was convicted on the basis of political statements which represented a legitimate point of view. JCE counsel argued that Krasnich was found guilty by association because he espoused a political view shared by those who committed war crimes. And then 694. Prosecution did not specifically respond to the issue of protected political speech. But importantly, perhaps 695, the appeals chamber finds that contrary to JCE counsel's allegation, the trial chamber did not find that the political activities of Krasnich formed the actus reus of any of the crimes against humanity of which he was convicted. Instead, Krasnich was convicted for crimes for which he was found criminally responsible under the mode of liability of JCE, which required that the defendant has made a significant contribution to the crime's commission. Tribunal jurisdiction does not require such contribution to be criminal per se. Indeed, the appeal chamber has explicitly held that the contribution need not involve commission of a specific crime under the statute. Moreover, the appeals chamber has repeatedly found that contribution to JCE may take the form of assistance in or contribution to the execution of a common purpose, and that it is not required that the accused physically committed or participated in the actus reus of the perpetrated crime. it is sufficient that the accused performed acts that in some way are directed to the furthering of the JCE in the sense that he significantly contributes to the commission of the crimes involved in the JCE. For these reasons, the Appeals Chamber holds that the contribution to JCE need not, in and of itself, be criminal. JCE counsel's claim to the contrary is dismissed.
But it is assuming that there was a common criminal purpose, and he was a party to the purpose, isn't it?
My Lord, yes, he was a party to, he was a party to the wider purpose, which is the ethnic, as we saw from the conviction, of the ethnic cleansing of the region. What the Appeals Chamber goes on to say is what matters in terms, this is the third sentence of 696, what matters in terms of law is that the accused lends a significant contribution to the commission of the crimes involved in JCE. Beyond that, the law does not foresee specific types of conduct which per se could not be considered a contribution to the common purpose. Within these legal confines, the question of whether the accused contributed to a JCE is a question of fact to be determined on a case-by-case basis. JCE counsel present argument is limited to a question of law. Appeals Chamber need not address this further. JCE counsel refers to Krasnich's mens rea, arguing that knowledge of crimes is simply not enough for mens rea when it comes to political speech, and a politician must be encouraged to continue to speak even with the knowledge that there are crimes being committed, unless he has been indicted for having made the speeches. The Appeal Chamber finds that the Trial Chamber did not hold Krasnich's mere knowledge of the crimes was sufficient to establish his mens rea. Instead, the Trial Chamber found that the information accused received during this period is an important element for the determination of his responsibility, because knowledge combined with continuing participation can be conclusive as to a person's intent.
That fits with Article 30 then of the ICC Charter, doesn't
My
it?
Lord, yes. JCE counsel failed to show that the Trial Chamber erred in this respect. So again, it's knowledge combined with continuing participation which can be conclusive to a person's intent.
And was there something because of his particular standing or anything that made that enough?
Well, my Lord, certainly in that analysis of the JCE concept, no particular reference is made to...
I'm not to talk here what Mr. Krasnich did. What did he do? Apart from making political speeches.
My Lord...
Did he do anything apart from making political speeches?
My Lord, it's 680 and 682. Appeals Chamber also held. This is page 236, my Lord.
236?
236, my Lord.
Yes.
At 680, the Appeal Chamber in Quarter held that in practice the significance of the accused's contribution would be relevant to demonstrating that the accused shared the intent to pursue the common purpose. This, however, does not amount to a legal requirement that the Trial Chamber take the significance, or in the words of JCE counsel, the substantiality or nature of the accused's contribution into account in assessing his intent. Assessment is more a matter of evidence than of substantive law. And then in 682, we have the Trial Chamber found that Krasnich's overall contribution was that he helped establish and perpetuate the SDS party and state structures that were instrumental to the commission of the crimes. JCE counsel argued that the words helped establish overstate his contribution because the Trial Chamber found he did not participate in establishing the SDS party. JCE counsel further argues that the Carriage Rule 92 term statement shows that Krasnich had no part in founding the SDS. The Appeal Chamber notes that on its face the impugned finding does not pertain to Krasnich's alleged participation in the establishment or founding of the SDS party as such, but instead to his help in establishing those SDS structures that were instrumental to the commission of crimes. They therefore misconstrue the impugned finding. So again, that's the contribution for which he was held liable. And we respectfully submit that there's nothing in that which detracts from the force and the applicability of the passages I took your lordships to summarising the law in the cases of Amicable.
I mean, if you set up, if you remember the organisation and set up the machinery by which the crimes are carried out, I have no difficulty in seeing that with them. But I mean, I don't see that that's the test of being knowledge combined with continuing participation. It seems to be a different way of looking at it.
My Lord, all I was taking, again, of course, the case we're concerned with is not with somebody who helped set up the LTT or the intelligence division in that sense. But what I was seeking to do is to show where Krasnich the approach Krasnich had taken on the basis of, the approach Krasnich had taken and how that was, in its approach, consistent with what was said in Tadic and what the law was as summarised in the Cassese brief. And while on the facts, Krasnich was not on all fours with this case, in my respectful submission, there's nothing in that case which would have warranted a revisiting of the approach taken by the tribunal in Tadic, which, as we will see, of course, informed both the Canadian courts in Ramirez and the other cases, and the IAT in Guru, which I would now like to take your lordships to, if I may, unless there's... Ramirez, we have all the Canadian decisions in volume 11 of the... Volume 11, tab 86. And we see there, and I apologise for the absence of page numbers. On the second page, just above the held, we see the note that the appellant had never been formally charged with a crime, and it was his own evidence which the Refugee Division used against him to exclude him. And this was an appeal from the Refugee Division. We then have 2 pages on, we have the league judgment, Justice McGuigan, where he identifies the issue just above paragraph 3, namely, in the case at bar, the crime in question is either war crime or crime against humanity. He notes just under 3 that the claimant is not a major war criminal. We do not have the benefit of times, places, descriptions of activities. Do not have witnesses. However, we do have the applicant's claimant's own testimony, which we believe meets the serious reasons for considering standard. That's what the Refugee Division held. There's then over the page under 1, paragraph 4, there's a dearth of authority with respect to the interpretation of the Convention. He refers to Graal-Matzen and sets out there the words serious reason for considering make it clear that it is not a condition that the application of 1FB, in that case, the person concerned has been convicted or formally charged or indicted of a crime. The person's own confession, the testimonies of other persons or other trustworthy information may suffice. On the other hand, the wording of the paragraph suggests that a person may be allowed to refute the accusations levelled at him, even if he has been convicted by a final judgment. If the person is able to establish his innocence, there's clearly no reason why he should be denied refugee status. In 5, dealing with standard of proof, he says the word serious reasons for considering also, I believe, must be taken, as was contended by the respondent, to establish a lower standard of proof than the balance of probabilities. The respondent indeed argued that serious reasons for considering should have the same meaning as the phrase reasonable grounds to believe, which is used again and again in section 19 of the Act with respect to inadmissible classes of person. Paragraph 6, while I see no great difference between the phrases serious reasons for considering and reasonable grounds to believe, I find no necessity exactly to equate the one with the other, although I believe both require less than the balance of probabilities. Serious reasons for considering is the convention phrase and is intelligible on its own. Nevertheless, a comparison with paragraph 19.1j shows that Parliament was prepared to contemplate a standard lower than the usual civil standard. This kind of case, moreover, it has led me to think that it would be extremely awkward to place one standard at the ordinary civil level and another for what is essentially the same thing at the lower level. Therefore, although the appellant relied on several international authorities to emphasise that the interpretation of the exclusion clause must be restrictive, it would nevertheless appear that in the aftermath of Second World War atrocities, the signatory states of the 1951 Convention intended to preserve for themselves a wide power of exclusion from refugee status where perpetrators of international crime are concerned. And of course, we find that on the next page at paragraph 9, where he cites a passage from Hathaway, setting out the compromise that was reached by the drafters. While the drafters of the convention were unanimous with the view that war criminals should not be entitled to claim refugee status, there was disagreement on 2 points. First, the United States argued that countries should be allowed to treat war criminals as refugees, although they should not be compelled to do so. Most representatives, however, were strongly of the view that discretion of this kind could undermine the integrity of refugee status. Compromise which emerged consisted of the mandatory exclusion of an undefined category of persons who had committed a crime against peace. This satisfied the majority of delegates who wanted a strong stand against the sheltering of war criminals. The United States was content that the definition was sufficiently vague to allow for an injection of domestic discretion. I do not view a less than civil law onus, however, as amounting to domestic discretion. I believe it's in accord with the international standard and assigns roughly equal weight to the term serious and considering within that standard. And then over the page, paragraph 11, he starts at what he calls the most controversial legal issue in the case at bar, has to do with the extent to which accomplices, as well as principal actors in international crimes, should be subject to exclusion. And he there notes, of course, one of the features that is always features in looking at international instruments, that he is there using the word accomplices in its American rather than its English, as he understood it, its English law sense. And there is therefore, of course, room for different interpretation just on a language basis. The Convention provision refers to the international instruments drawn up to make provisions in respect of such crimes. One of these instruments is the London Charter, and he refers to Article 6. I believe this evidence is decisive of the inclusion of accomplices as well as principal actors, but leaves to be answered the very large question as to the extent of participation required for inclusion as an accomplice. Then notes in the last sentence of paragraph 13 that an international convention cannot be read in the light of only one of the world's legal systems. Refers to Hathaway in paragraph 14 and the US case law in Fedorenko or in Lipinieks, which refers to Fedorenko and Osidach. Paragraph 15, I'm not unmindful of the dangers of reading an international convention in the light of the interpretation of domestic American law by American courts, but I do not propose to do so. Nevertheless, the American case law represents a helpful starting point as to the meaning of the word committed in the convention. From the premise that a mens rea interpretation is required, I find that the standard of some personal activity involving persecution, understood as implying a mental element or knowledge, is a useful specification of mens rea in this context. Clearly, no one can commit international crimes without personal and knowing participation. What degree of complicity then is required to be an accomplice, or better, a first conclusion I come to is that mere membership in an organisation which from time to time commits international offences is not normally sufficient for the exclusion from refugee status. And he then cites Graal-Mattson at page 277 in relation to post-international military tribunal case law. It seems apparent, however, that when an organisation is principally directed to a limited brutal purpose, such as a secret police activity, mere membership may by necessity involve personal and knowing participation in persecutorial acts. Similarly, mere presence at the scene of the offence is not enough to qualify as personal and knowing participation, nor would it amount to liability under Section 21 of the Canadian Criminal Code, though again, presence coupled with additional facts may well lead to a conclusion of such involvement. In my view, mere onlooking, such as occurs at public executions, the onlookers are simply bystanders, with no intrinsic connection with the persecuting group, can never amount to personal involvement, however humanly repugnant it might be. However, someone who is an associate of the principal offender can never, in my mind, be said to be a mere onlooker. Members of a participating group may be rightly considered to be personal and knowing participants, depending on the facts. At bottom, complicity rests in such cases, I believe, on the existence of a shared common purpose and the knowledge that all of the parties in question may have of it. Such a principle reflects domestic law and, I believe, is the best interpretation of international law. And then looks at, over the page at paragraph 22, one must be particularly careful not to condemn automatically everyone engaged in conflict under conditions of war. Probably most combatants in most wars in human history have seen acts performed by their own side which they would normally find reprehensible, but which they felt utterly powerless to stop, at least without serious risk to themselves. While the law may require a choice on the part of those ordered actually to perform international crimes, it does not demand the immediate benevolent intervention at their own risk of all those who are present at the site. Usually, law does not function at the level of heroism. In my view, it's undesirable to go beyond the criterion of personal knowing participation in persecutorial acts in establishing a general principle. The rest should be decided in relation to the particular facts. And we again would emphasise the fact that, of course, ultimately, what the IAT sought to do in Gurung was to provide guidance to decision makers as to how appropriately to consider whether they could reasonably form the view that there are serious reasons for considering that an individual is internationally committed, responsible for war crimes. And we then have, at paragraph 37, we have the court looking at the facts. And we would emphasise the last sentence of paragraph 37. He was an active part of the military forces committing such atrocities, he was fully aware of what was happening, and he could not succeed in disengaging himself merely by ensuring that he was never the one to inflict the pain or pull the trigger.
What was his standing in all this? Have we the least idea?
He was... Well, in paragraph 35, the appellant admitted presence at many instances of torture and killings committed by other soldiers under orders from their common superiors. I'm talking about, in speaking in a summary way of his experiences, the appellant testified as to what he saw. Yes, I'm talking about ordinary conduct, also talking about getting people unarmed, torturing them and killing them. Initially motivated by revenge for the murder of one sister and her husband by the guerrillas and the rape of another, the appellant enlisted voluntarily in the Salvadorian army for 2 years as of 1st February 1985 and was such an effective soldier that he was promoted to corporal and then to sub-sergeant. During this period, he was involved in between 130 and 160 instances of combat. 2 months before his term was up, he was wounded in an ambush in foot, leg and head. During his recuperation, he signed up for 2 more years of service so that his hospitalisation and convalescence would be paid for and his salary would continue.
Then it's really the middle of the next one page. I find it clear. Torture and killing of captives become a military way of life. But this chap's conscience greatly troubled it.
My lord, yes, it
And
becomes a military way of life.
Requested discharge, eventually deserted.
Yes, and then he says, I also have to say, however, that I think it's not to his credit that he continued to participate in military operations leading to such results over such a lengthy period. He was an active part of the military forces committing such atrocity, was fully aware of what was happening, and he could not succeed in disengaging himself merely by ensuring that he was never the one who inflicted the pain or pulled the trigger. On a standard of serious reasons for considering that he has committed a crime against peace, war crime or crime against humanity, I cannot see the appellant's case as even a borderline one. He was aware of a very large number of interrogations carried out by the military on what may have been as much as a twice-weekly basis. During his 20 months of active service, he could never be classed as a simple onlooker, but was on all occasions a participating and knowing member of a military force, one of whose common objectives, and again, this recognises that there can be a multiplicity of common objectives, was the torture of prisoners to extract information. This was one thing his army did regularly and repeatedly, as he admitted. It was part of the operation, even if he personally was in no sense a cheering section. In other words, his presence at this number of incidents of persecution, coupled with his sharing in the common purpose, clearly constituted complicity. And in the last sentence, the applicant was no innocent bystander. He was an integral, albeit reluctant, part of the military enterprise that produced those terrible moments of collective, deliberate inhumanity.
In paragraph 41 refers to his persistent and participatory presence.
My lord, yes.
So he was obviously very close to events.
My lord, yes. My lord, we saw that he...
He saw them happening.
Yes, he saw the torturing and the killing happening, but it also recognises in paragraph 39 the difference between, or the need to convict the appellant of criminal liability for his action would of course require an entirely different level of proof, but on the basis of the lower than civil standard established by the nations of the world. When there's a question of international crimes, I have no doubt that a properly instructed tribunal could fail, no properly instructed could fail to come to the conclusion that the appellant has been personally and knowingly involved in persecutorial acts. And then we see at final page Justice Stone Linden agreeing. We have Moreno at tab 18.
So when he's in 39, is he talking about the Refugee Convention standard there, is it?
Yes, my lord. The lower than civil standard is a reference back to what he said at paragraphs.
We failed to come to the conclusion they had.
Paragraph leading up to paragraph 9 is the kind of the serious reasons for considering standard being a standard that is lower than the civil standards on the balance of probabilities.
I would have thought that the conclusion that you might not be able to fail to reach would be that he may have been personally involved or something like that. I mean, you've got reasonable grounds to say. I mean, it's reasonable ground or whatever. I mean, you're not concluding that he has done it, have you? But good reason or good whatever the standard is.
Yes, I mean, I think that's why he prefaces this, that on the lower standard, the lower than civil standard, no tribunal could be. Yes, I mean he's missing out the words of the convention, which is that no reasonably properly instructed tribunal could fail to come to the conclusion that there's serious reason for considering that he committed those crimes. My lord, yes.
987, did you say? This is the next
My lord,
one?
we have Moreno at 82.
Oh, 82.
But that to a large extent restates the issue. And if I could ask your lordship to turn to 2 sheets from the back, and again I apologise for the form of these. We see him considering the question, did the board err in law?
How does the page begin? Sorry.
Letter D. The page begins in the killing of civilians. So it's on the left-hand side, two sheets in. And we see third full paragraph starts D. Did the board err in law determining by determining that the male appellant's acts and omissions amounted to a crime against humanity? And then summarises under 1 that membership is not enough. Ramirez, an exception to this general rule arises where the organisation is one whose existence is premised on achieving political or social ends by any means deemed necessary. Membership in a secret police force may be deemed sufficient grounds for invoking the exclusion clause. Membership in a military organisation involved in armed conflict with guerrilla forces comes within the ambit of the general rule and not the exemption. So again, this is a member of the Salvadorian army who had been forcibly recruited at the age of 16. And there, the court noting that he's not a member of an organisation with a limited brutal purpose. Then the next page, he sets out, having set out a quote from Dunlop and Sylvester, he sets out the paragraph starting with while mere presence at the scene of crime torture is not sufficient to invoke the inclusion of the act of keeping watch with a view to preventing the intended victim from escaping may well attract criminal liability. Instant case, however, the appellant could not have assisted in the prisoner's escape because he was never in possession of the key to the cell. In any event, the determination of the appellant's complicity should not hinge on possession of the key. It remains to be determined whether the appellant should have attempted to prevent his superior officers from continuing with their acts of torture, as was inferred by the board, and then refers to in detail to Ramirez and 3 paragraphs up from the bottom, applying the above reasoning. This is the reasoning of Justice McGuigan in Ramirez. We must determine whether the appellant's conduct satisfies the criterion of personal and knowing participation in prosecutorial acts. Equally important, however, is the fact that complicity rests on the existence of a shared common purpose, as between principal and accomplice. In other words, mens rea remains an essential element. In my opinion, a person forcibly conscripted into the military and who on one occasion witnessed the torture of a prisoner while on assigned guard duty cannot be considered at law to have committed a crime against humanity.
Those are the only facts we need, are they?
My Lord, those are, the facts are also summarised in the headnote, but in a sense that is all that is needed, because in the end the tribunal concluded, the court concluded that the tribunal had misdirected itself.
Yes, he was unlike Ramirez, who was a voluntary participant.
But they note at the page we were just at, the references from Mr. Sharif Bassioni in Crimes Against Humanity in International Criminal Law, to the effect that the further one is distanced from the decision maker, assuming that one is not a principal, then it is less likely that the required degree of complicity necessary to attract criminal sanctions on the application of the exclusion clause will be met. I take it for granted that a 16-year-old foot soldier will not be accorded the same legal treatment as those who commanded the war, and then draws the distinction with Ramirez. And finally, in the Canadian cases, there is Sivakumar,
Tab number?
which is tab number 89, my lord. And again, this is Federal Court of Appeal.
They're all Federal Court of Appeal, are they?
All the ones I've taken your lordship to are Federal Court of Appeal. And we have there Justice Linden on the third page, last sentence identifying the issue on this appeal is whether the appellant was properly held responsible for crimes against humanity alleged to have been committed by the LTTE, even though he was not personally involved in the actual commission. So, third page, just above the law.
It's halfway down.
So not
the
third
page.
sheet, third page, my lord, second sheet.
Halfway down?
Halfway down, just above the words in capital letters underlined the law.
Yeah. Sorry, just under those words, what are you reading out? The definition of...
No, sorry, what I was reading out was above the letters, the law, what the issue was. Namely, whether he could be properly held responsible for crimes against humanity alleged to have been committed by the LTTE, even though he was not personally involved. And what we will see over the page is the judge considering the question of complicity by reference to Ramirez, again, and Moreno, we see in the first paragraph under complicity, and at the bottom by reference to an article from Mr. Rykoff, from whom there are also two articles before your lordships. Next page, another type of complicity particularly relevant to this case is complicity through association. In other words, individuals may be rendered responsible for acts of others because of their close association with the principal actors. This is not a case merely of being known by the company one keeps, nor is it a case of mere membership in an organisation making one responsible for all the international crimes an organisation commits. See Ramirez, neither of these by themselves is normally enough unless the particular goal of the organisation is the commission of international crimes. It should be noted, however, as Justice McGuigan observed, someone who is an associate of the principal offender can never, in my view, be said to be a mere onlooker. Members of a participating group may be rightly considered to be personal knowing participants depending on the facts. In my view, the case for individual complicity in international crimes committed by his or her organisation is stronger. The individual member in question holds a position of importance within the organisation. Bearing in mind that each case must be decided on its facts, the closer one is to being a leader rather than an ordinary member, the more likely it is that an inference will be drawn that one knew of the crimes and shared the organisation's purpose. Thus, remaining in an organisation in a leadership position, with knowledge that the organisation was responsible for crimes against humanity, may constitute complicity, and again, reference to Bassioni. Thus, the closer a person is involved in the decision-making process, and the less he does to oppose or prevent the decision or fails to dissociate himself from it, the more likely that person's criminal responsibility will be at stake. Such circumstance is an important factor to consider as evidence individual protested against the crime or tried to stop its commission or attempted to withdraw from the organisation. And the court then looks to the Article 6 of the Charter for the International Military Tribunal in relation to the concept of leadership within an organisation. But just above that paragraph, of course, Mr. Justice McGuigan has written, law does not function at the level of heroism. Its people cannot be required, in order to avoid a charge of complicity by reason of association with the principal actors, to encounter grave risks to life or personal security in order to extricate themselves from a situation or organisation. But neither can they act as amoral robots. And he then sums up right at the bottom of that page. To sum up, association with a person or organisation responsible for international crimes may constitute complicity if there is personal knowing participation or toleration of the crimes. Mere membership in a group responsible for international crimes, unless it's an organisation that has a limited group of purpose, is not enough. Moreover, the closer one is to a position of leadership or command within an organisation, the easier it will be to draw an inference of awareness of crimes and participation in the plan to commit the crimes.
I mean, that's a different, he formulates that at the end there slightly differently from how he formulates it in the first full paragraph on the previous, in the second full paragraph on the previous page, where it says that the closer you are, being a leader, the more likely it is an inference will be drawn that one knew of the crime and shared what he calls there the organisation's purpose in committing the crime, which is not, doesn't seem to be quite the same as what he's saying at the top of the following page.
I'm not. Is it?
Well,
Not,
one
not
place.
to understand your lordship's question.
Well, he's saying he says you inference on the paragraph beginning, in my view.
Yes,
The closer you're, the easier it will be to draw the inference that he knew of the crime. That's common to both passages, and shared the organisation's purpose in committing the crime is the test.
Yes,
there. On the top of the next page, it's a participation in the plan to commit the crime.
Yes, my lord. No, I can see that. So that his summary is the narrower one, and we say the appropriate one is the former.
Sorry, can you say that again?
We say that the right expression of the test is that he. So let me just get the wording.
Shared the organisation's
the
purpose in committing that crime.
Yes.
And what would that be, for example?
Well, we looked at the question of purposes before the short adjournment, and of course there is a multiplicity of purposes any organisation can have, but one of the purposes which the case law identified, and one of the purposes which the LTTE pursued, was that effectively any means were necessary to achieve their political aim. That included the systematic and planned commission of war crimes and crimes against humanity, and that, in our respectful submission, that plan and that system to engage in those crimes is the plan he supported. Whether he supported the individual suicide bomber sent to kill Rajiv Gandhi is a different matter, but the plan is that was part of what they were engaging in, and which was part of their makeup. My lords, that's just showing your lordship how the Canadian courts in the mid-90s came to apply the London Charter and to some extent the case law thereunder in order to reach the conclusion that persons fall to be excluded on principles akin to those which we've just identified as part of the JCE concept in international criminal law. Conscious of the time, there are two, on this issue, there are two further matters I wanted to take your lordships to. One is Gurung, and the other is the two decisions of the German courts, which are, in a sense, the most recent and the only European decisions we have, which we say are of particular relevance because, of course, they go to the interpretation of the directive. So, with your lordship's leave, I will perhaps start with the latter and then return to Gurung, if I may, in the sense because Gurung is, of course, the most detailed consideration of this issue in the domestic context, but it is also, of course, a decision of the IAT and therefore, of course, of persuasive value, but it may be of more help to your lordships if I took your lordships to the German decisions first.
Yes, all right.
And those we have at volume 10, paragraph 70,
Tab 70.
tab 75. Perhaps I could ask your lordship to turn to tab 74 first.
Do we have oh yes, the date. It's October 2008.
My lord, yes.
Sorry,
Am I looking at the... If your lordship just go with me one...
But do you want us to go to 74, you say?
Yes, my lord.
Oh.
Your lordship will recall from our printed case, there are two references currently pending before the European Court of Justice relating to 1FB and 1FC. And all I was going to do is to indicate that, as we understand it, the reference question set out at tab 74 is the question that arises out of the decision, the judgment, which I'm about to take your lordships to, at tab 75. And this is a translation by the German authorities. It's on the Federal Administrative Court's website, which, as your lordships will know, is their supreme administrative court, and the highest court in Germany in matters of administrative law. And the decision is that of 14th of October 2008, at page 2, and we see the decision and the order on page 2.
What's the case called?
My lord,
You don't call
the reference is called D, by the letter D, but one of the annoying things about German law is that they don't refer to their cases by name at all, but only by citation. It's as if I were to refer a case to your lordship by 2009 1AC 360 and expect everybody to know what I'm talking about. But it's
Where do we find that number?
we don't find that either because it's not yet published in a report.
Very useful.
This is taken from the Administrative Court's website, where they have an English section where they publish what they consider important decisions of their own, which may be of relevance to the wider debate.
And for citation purposes, is the reference on the frontispiece, the one that one we give?
My lord, yes, the first one, the BVERWG 10C 4807, is probably the most appropriate reference for purposes of citation.
Yes. It suggests the litigation began in 2007. That be?
My lord, I'm not
Simply the
not
07
sure
date.
it does. It's I'm not sure it does. I've never quite worked out. Of course, the original decisions go to. Your lordship will see at page 7, effectively. The first decision was the Gelsenkirchen Administrative Court on the 13th of June 2006, and there was then a Higher Administrative Court of North Rhine-Westphalia in 2007. So whether the 07 makes a reference to the year, I would hesitate to confirm. And the only thing I really wanted to take your lordship to is because this is, of course, a court who has stayed its final decision, pending the outcome of the reference, but has given, as we see at page 10, its view as to the appropriate answer. And we see that at paragraph 17, page 10, about 6 lines from the bottom, even though the complainant says he himself, do your lordships have that, take part in armed conflict, he supported the fighting troops in various ways. He scouted routes and arranged for supplies. In those activities he was armed, which in any case permits the conclusion that he was also willing to use his weapons if necessary. Thus the complainant actively supported the armed struggle of an organisation that appears on the list of persons, groups and entities annexed to the common position on the application of specific measures to combat terrorism, and that applies terrorist methods. And we then have in paragraph 21 on page 12 a reference to Article 12.3 of the directive, which your lordships will recall is the one that talks about otherwise assisting. And under Article 12.3 of the directive, the reasons for exclusion also apply to a person who instigate or otherwise participate in the mentioned crimes or acts. Thus, the person seeking protection need not have committed the serious non-political crime himself, but he must be personally responsible for it. This must in general be assumed if a person has committed the crime personally or made a substantial contribution to its commission in the knowledge that his or her act or omission would facilitate the criminal conduct. Thus, this principle covers not only active terrorists and participants in the criminal sense, but also persons who perform advanced acts in support of terrorist activities. And there's then a reference to decision of the Federal Constitutional Court. In this court's opinion, all 3 prerequisite facts are met in the case of a person who actively supported the armed struggle of a terrorist organisation. So that the answer to question 1 is presumably in the affirmative. And that reference is now pending, and pleadings have been exchanged, and it's waiting for a listing in the Court of Justice.
I mean, that was on subparagraphs A and B.
That was a paragraph, subparagraphs B and C, my lord.
I mean, what did I, sorry, yes, B and C. I know. I mean, I thought your printer case say, therefore it didn't,
No, my
going
lord,
to
but
affect us.
No, but what it does, and that, the reason I referred you to paragraph 21, is that it does explain what the German courts view the function of 12.3 is, and the otherwise participate.
So does 12.3 extend over B and C as well as A?
My lord, 12.3 extends as... Yes, it does, my lord, because it refers to paragraph 2 rather than paragraph 2A.
I see, yeah. Right.
But more importantly, what I wanted to do is to take your lordship to the next decision, which is at tab 77, which is the Bavarian Higher Administrative Court. So it's the German equivalent of the Court of Appeal in administrative matters. This is a translation provided by the FCO's translation and interpretation services for the purposes of this hearing, and therefore not an official translation, and relates to a judgment of the court which we see on page 1 of the 21st of October, so about a week after the order for reference was made.
Sorry, where do we see that?
So this is the bold figure on the page just before page 2.
Oh, yeah.
And then if I could ask your lordship to turn to paragraph 40.
This is another Turkish Kurd.
This is another PKK case, my lord, yes.
And was the first one also the PKK under another name? Or
No, the first case was also a case involving...
it was a Turkish Kurd.
PKK. It was the DHKP. So it was a death soul. So it was another Turkish Kurdish separatist organisation listed in the common list of the EU's common list of terrorist organisations.
Thank you.
In which, of course, the LTT is also listed. If we then have paragraph 38, those acts fulfilled the requirements. This refers back to the facts. All the requirements of paragraph 3.
I'm completely lost. What is he supposed to have done?
Yeah.
My lord, the facts are not summarised, are set out in details, starting with starting at paragraph 2, my lord. He was a Kurd, he'd been with the PKK since he was 15. He stayed in the city of X on the instruction of that organisation in order to recruit new people. There he had been arrested and interrogated under torture by the police. Then been taken to the police department where he was questioned under torture. That followed stays in prison Mardin and Diyarbakir. He was sentenced to 12.5 years imprisonment as a member of the PKK, was released in 2000. In the following month he went to stay with his parents.
Yeah, that tells us why he's seeking refuge. It doesn't tell us why they're denying him or whether they're being asked to deny him.
Well, it's then in paragraph 4, in answer to the question whether he held a rank within the PKK, the plaintiff stated after initial hesitation that he had been appointed commander of the X. However, he had not taken up that office since even at an early stage he did not consider the political line to be correct. When he joined the PKK, he had supported freedom for the Kurdish people. After he joined that organisation, he noticed that by the deviation of the political line, and we see the translator's note, it could be from the political line, it no longer supported that goal. For that reason, in 2004, he left the PKK.
I think paragraphs 70 and 71 possibly are what there is on this particular man's involvement.
My lord, yes, I apologise. Page 31.
I see. So he was active for a considerable time before, because paragraph 35 contains a list of various atrocities that were carried out from 1987 onwards. So that would fit with the timetable that's referred to in paragraph 71.
70, my lord, yes.
But he seems to have engaged in these activities, supporting and facilitating.
My lord, yes, and again, this is not because on the facts it is necessarily on all 4, but if we see 71, the activities in which he engaged from 87 until his arrest in 91 were such as to support and facilitate such offences. At the same time, his activities at that time fulfilled the factual precondition for participation under 25.3d1 of the Rome Statute. So we see the German court's interpretation of that provision. Since, as observed in section 121 above, the carrying out of terrorist acts and commission of war crimes, crimes against humanity, that time characterised the action of the armed wing of the PKK, specifically in the southeast of Turkey, he must, in the view of the UNHCR, as expressed in, it should probably be paragraphs 19 and 26 of the guidelines for September 2003, accept responsibility for the PKK's conduct. If by his own account, from the beginning of his activity for the PKK till his formal entry into the ranks of fighters, he first travelled as a messenger between various guerrilla units and accompanied the irregulars of the PKK as someone who knew the rural environment well. He therefore had to expect that by that activity he would not only be furthering the PKK's attacks on the Turkish armed forces, the gendarmerie and other organs of the Turkish state which confronted the PKK in a combat-like manner, he also always had to proceed on the assumption that the unit which he was guiding through the terrain familiar to him was on its way to an operation which must be characterised as a terrorist act, as a war crime or as a crime against humanity, or that the message or the weapon which he was carrying was to serve to carry out such a criminal offence. This reality must have been all the more unavoidable to him when he was in possession of a grenade at the time of his arrest, a grenade which, according to his own statement, he was supposed to transport for the PKK. Such weapons can, it is true, also be used in open combat with the armed forces and the gendarmerie of the Turkish state. Since the use of explosives such as grenades is, on the other hand, one of the classic tools of terrorists who want to kill and injure a maximum possible number of people, see the reference to them in Article 1E of the European Convention on the Suppression of Terrorism, and the PKK actually used grenades, at least in the massacre of Pinachik, the plaintiff could never be sure that he was not supporting a terrorist operation when he transported such weapons. It can remain undecided in the present case whether acts of support which are limited to the spiritual and intellectual sphere or stop at a non-violent act also entail a legal consequence of Article 1F of the Geneva Convention. This is because during the hearing before the Federal Court, the plaintiff admitted having also received training in weapons. that circumstance and its willingness to transport equipment such as grenades which are dangerous to the public for the PKK show that he had accepted as his intention the PKK's operational repertoire in its entirety. Purely for the sake of completeness, it should nevertheless be noted that Article 1F of the GLC does not require strict proof that a person has actually committed one of the acts which preclude recognition as a refugee. Those provisions are, on the contrary, satisfied if, for serious reasons, a presumption to that effect is justified. Since Article 3.2 of the Asylum Procedure Act refers to Article 3.2, Sentence 1 in its entirety, an instigation, aiding and abetting, or other measure of support in relation to acts within the meaning of Sentence 1 also does not need to be demonstrated with complete certainty if, in any case, a high degree of probability points to the person concerned having objectively furthered war crimes, crimes against humanity, or other terrorist activities, and of having been aware that the organisation for which he is active plans acts covered by Article 1F of the Geneva Convention, and his contribution could be conducive to the carrying out of such act.
So what's happened to this case?
This case is, his appeal was dismissed. It was not stayed. The court felt it was act clear, or it didn't consider whether it was act clear, but it didn't feel the need to refer, and therefore, as is clear from the judgment on page 2, his action, i.e. his appeal, is dismissed.
But the case has been referred.
This case hasn't been referred.
Oh, it has not, I beg your pardon.
This is not referred. This
Yes.
is a final decision
Right.
in relation to the asylum question, setting
There's
out...
there's a bit in paragraph 74 about the age of criminal responsibility possibly being less than full age. Does the Secretary of State have a position on that? Do you know?
My Lord, your Lordship will have seen that the decision letter took the view that it, in line with the Rome Statute, that the decision maker only looked at activities since he started at the age of 18.
And the Rome Statute actually says
The
that.
Rome Statute makes reference to that, as far as I recall. But so the Secretary of State certainly isn't relying on paragraph 74 to suggest that an earlier start date of the consideration of the evidence would be appropriate in this case.
Thank you.
Yes.
But this is, we say, a final judgment of a German court setting out in detail the approach they take to this question. And perhaps one final question, very conscious of the time, but perhaps I can close this case
Yes, please.
there.
Yes.
Is paragraph 63,
63.
63 at page 26,
Yes.
and paragraph 64. Cannot be proved that the plaintiff was a joint perpetrator or as an accomplice in the criminal law sense, even only in one of the acts constituting factual preconditions of Article 1F, which PKK activists committed between his joining and his arrest in 91. Particularly, it cannot be shown that he had positive knowledge that any of the information or weapons which, by his own account, he conveyed for the PKK at that time was intended to enable or facilitate the commission of such an act, or that the irregular soldiers, to whom he provided help in finding their way around the terrain, were en route to such a crime. The concept of otherwise participate in the acts listed in 321 of the Asylum Procedure Act, which is used in paragraph 3.2, sentence 2 of the Asylum Procedure Act, which is of course the language of 12.3 in the directive, must however be construed in the light of the relevant provisions of international law in such a way that any active involvement in a grouping which plans acts covered by paragraph 3.2, sentence 1, is sufficient for its purpose if the person concerned knows that the general intention of the group, knows of the general intention of the group, that should probably be, his contribution is objectively capable of furthering such acts, and the act of support is carried out in the knowledge that a course of conduct covered by that paragraph of the Asylum Procedure Act may possibly be objectively aided or abetted by it. The necessity of starting from a widely defined concept of participation follows first from the obligation of the Federal Republic of Germany and the European Community to take into account in framing both national and community refugee law the requirements to act and to refrain from acting which arises from Security Council resolutions 269 and 1373. intention of the Security Council to define as widely as possible the range of acts, perpetration of which will result in a person being regarded as involved in terrorism can be inferred from those requirements. Resolution 1269 had already mentioned, in addition to the commission of terrorist acts, as types more distant involvement, the perpetration and financing, see number 4, second indent, the planning, third indent, of such offences, and other participation in them, fourth indent. Resolution 1373 extended the forms of possible involvement to those set out, in addition to the forms of conduct of committing and participating, can be the separate mentioning of preparing, supporting, planning, organising, financing, facilitating and providing a safe haven, in addition to the forms of conduct of committing and participating, can be understood only as meaning that not only activities which, from the perspective of German criminal law, must be classified as aiding and abetting terrorist acts were to be covered, but that the resolution also incorporates in its legislative content forms of conduct which in criminal law do not suffice to constitute aiding and abetting, because the person acting does not even know in rough outline the act whose commission he is furthering. This is because terrorist activities are also facilitated by, for example, anyone who creates an infrastructure which is conducive to the commission of terrorist acts, e.g. in the form of keeping available premises suitable as places of refuge or rest or as arms depots, without knowing which actual perpetrator will use that infrastructure at what time in the preparation for or following what acts. And then in 65...
Well, I think I'm going to stop you here. There are paragraphs you'd like us to read, would you? 65?
My Lord, 65 and 66
Yes.
take us to the rest of the consideration really by the German court. And then in 68, your Lordship will see a reference to the judgment of the
Yes.
Federal Supreme Court, which I referred to, erroneously citing paragraph 20, which is the paragraph 21 I took your Lordships to, and paragraph 69.
Yes. Well, we'll have to rise now. Obviously, you still have to deal with the important case of Gurum. How long do you think that's going to take you to do?
My Lord, taking Gurum and the UNHCR's approach, which I can probably take relatively briefly, there's then the matter left over in relation to standard of proof, insofar as your Lordships wish me to address that further, which was raised not as a ground of appeal, but is raised in the respondent's case as to whether it should be the balance of probabilities rather than a lower standard.
I think we could perhaps reserve that for
If I reserve that to reply, I will do my very best to be finished possibly well within half an hour, but I will need that time in order to take your Lordship to Gurum.
Saying, supposing we were to sit at 9:45, which should add on 3/4 of an hour, how would that be?
Lord, I would be hopeful then, if not finishing by lunchtime, certainly finishing early on.
And then time for a reply. I think to be safe, we should sit at 9:45, if my colleagues are content with that. Very well, 9:45 tomorrow, and hope very much that you manage to complete by 10:30.
My Lord, I will certainly...
So that gives Mr. Singh a full
certainly
stretch.
do my very best to do that.
Yeah. Thank you very much.